8-3-202. That section applies to all actions to recover damages for any deficiency in the design, planning, supervision, observation of construction, or construction of an improvement to real property.
Mr. Howell, let me ask you a question, if I might, sir. Let's assume that East Tennessee Sprinkler put this system in 1992, and then the owner of the property hired Joe's Inspection Service to inspect the system and to do maintenance on it in the future years. And Joe's Inspection Service didn't discover the alleged deficiencies in the sprinkler system. Is it your position that the statute of repose would bar the action against Joe's Inspection Service?
In that particular hypothetical, where Joe's Inspection Service did not install it, and where you have a complaint that properly alleges sufficient facts to establish a breach of contract claim or a negligent inspection claim against Joe's Inspection Service, in that particular situation, which I would assert is not the situation in this case.
Oh, I know it's not the situation.
Not the situation in this case. In that particular case, I do not think that the statute of repose would bar it in that hypothetical, which is not this case.
Okay, and then
Because why?
that was my question.
Sorry.
Because that would be, it must, the repose applies, let me see here. That would be because that would not be against the person or the entity that installed the sprinkler system in our case or in that hypothetical. That's how I would read that.
So is it simply because it's the same party that installed it and inspected makes it different than Justice Tarwater's hypothetical?
I think in this case, the difficulty is, in the challenge is we have to look at the allegations of this particular complaint, and I do not think that this complaint sufficiently alleges a defective or negligent inspection. It doesn't sufficiently allege a breach of contract. There's no contract attached. There are no invoices attached. There are no inspection reports attached, as were alleged in the brief. And in that situation, in this particular complaint, it is barred by the statute of repose.
Well, let me circle back to Justice Tarwater's question.
Okay.
You're saying that the cause of action against Joe's would not be barred. On what language in the statute do you rely to distinguish that situation?
So the language I would look for, and this is what I was looking for when the question was first asked, must be brought against any person performing or furnishing the design, planning, supervision, observation, construction.
Sorry, what statute are you looking at? The statute of repose itself?
Yes.
28.330.
Yes,
Okay.
Justice Kirby, yes.
And
yes.
what language again would you say?
I would look at the language in that statute must be brought against any person performing or furnishing the design, planning, supervision, observation of construction, or construction of the improvement within 4 years after substantial completion of an improvement. So that is the language I would be looking at. And in that hypothetical that Justice Tarwater raised, Joe's Inspection Service, Joe's is not a person performing or furnishing design, planning, supervision, observation of construction, or construction of the improvement within 4 years. In this case, East Tennessee Sprinkler, as is not disputed and as alleged in the complaint, the sprinkler system was installed in 1992. And so by virtue of that, and by virtue of the facts that are the actual facts that are in the complaint, it is that person. It is any person
But
And
what do you do with the first sentence of that same statutory language? It says all actions, and I'm going to skip a little ahead, for deficiency in design, planning, supervision, observation, or construction. It seems to limit it from that language you quoted. And then here we have the paragraphs in the complaint that talk about inspection, testing, maintenance, and repairs, which are not the same as design planning. How do we make the leap that you're making?
I'm not sure I'm following your question. Are you asking, because what is alleged in the complaint, as I read it, is not what they're alleging in the complaint is, if I'm understanding your question, they're trying to allege that
Maybe
we had...
if I try to reword my question, it was not well worded. You say that the statutory language talks about claims against any person designing, constructing, but the beginning of that same statutory language limits that to, or seems to limit it to only actions related to designs in construction. So if it's against a person who constructed it before a different type of action, does that still
I can
limit?
see where that goes, but again, I would draw the court back to the actual allegations of the complaint. And in this actual complaint that was pleaded, it is asserted and it is alleged in the complaint, in those initial paragraphs, 5 through 8 of the complaint, that East Tennessee Sprinkler was the person who did that, who did the installation, and therefore they would fall under that, they would fall under the statute of repose given the particular allegations of the complaint. And I think given what, in this case, the plaintiff is the master of the complaint, and we have to approach and defend on behalf of the defendant. We have to deal with the actual complaint that's alleged, and the actual complaint that's set forth alleges that East Tennessee Sprinkler was the person who was in charge of the design, the planning, supervision, or construction of the improvement. And because East Tennessee Sprinkler was that person, they are protected or receive the benefit of the statute of repose.
But that's only because, I guess, the theory, or at least, I guess under one argument, the theory of liability is that it stems from the installation and not from the later, negligent supervision, et cetera. But you seem to be relying pretty heavily on the language in Red Wing that, in our opinion, in Red Wing that, says that if a statute of limitations or I guess the statute of repose defense is apparent from the face of the complaint, then the burden then shifts to the plaintiff to present a colorable basis for, an exception from that. Here it seems to me that the only reason why the statute of repose, defense is apparent from the face of the complaint is that the date of installation was actually included in the allegations of the complaint. Would this come out differently if the date had not been included?
Again, let me answer that question a couple of ways. First, again, I would draw the court back to what we were faced, what East Tennessee Sprinkler was faced with was we have to deal with the complaint as is. And when you look at the complaint as is, there are very few facts that are actually pled, and that is one of them. And so what I don't want to, I want to make sure that we're looking at the actual complaint. If those facts, if the plaintiff had pled different facts and taken and not alleged facts that made it apparent from the face of the complaint, yes, the strategy and the defense would have been different. But what we had when this complaint, when it first came in, is it is apparent from the face of the complaint that that East Tennessee Sprinkler is protected by the statute of repose. And I think...
Let me ask you this. We're also required in the posture in which this case comes to us on a 12.026 motion. We're required to assume that the facts are true, that the allegations in the complaint are true, and we're required to draw all reasonable inferences in favor of the plaintiff. So what we have here is a situation where the complaint provides the date of installation. So, there is the existence of the statute of repose and the statute of repose, and the potential application of that is apparent from the face of the complaint. But we have really no allegations regarding, whether the water damage in this case was whether the problem that caused the water damage in this case was present at installation, or rather, occurred at a later date, which could make the damage caused by the later negligent supervision rather than a defective installation. So we just don't have anything about that. But since we're at a 12.026 posture where we're required to construe the reasonable inferences, or we're required to, give the plaintiff all reasonable inferences. I mean, why can't we reasonably infer from the allegations of the complaint that that problem postdated the installation, the sloping problem postdated the installation?
I understand your question, Justice Campbell. I think where we would go back to the complaint, is that in paragraph 7 of the complaint, the subject sprinkler system is designed as a dry system such that water should not remain in the lines. Due to the improper sloping in this is paragraph 8, due to the improper sloping in the sprinkler system, water was allowed to pool in the lines. I think from what we see there is we have a factual allegation of a design defect present from the very beginning.
How does it say that?
I'm sorry?
How does it say that? It says that the sprinkler system is designed to be a dry system. What language are you particularly relying on to establish that the sloping arises out of a deficiency in the design or the construction?
I would focus on this. The design is supposed to be dry, meaning no water.
That's one paragraph.
That's one paragraph. Due to the improper sloping in the sprinkler system, water was allowed to...
That's another paragraph.
Correct.
How do we know that the sloping was not the building settled or something? I mean, the burden of establishing that you are entitled to the protection of the statute of repose is on you, and you have emphasized over and over again the actual language in the complaint. So I would like for you to point me to the actual language in the complaint that says that the sloping is a defect that arises out of the design or construction.
I think what you do, and my response to that would be to just go through the complaint. East Tennessee Sprinkler installed the system in 1992. If we read the complaint and the facts alleged, and candidly, these are really the only specific facts that are alleged in
What particular language are you relying on, and in which paragraph, to establish that the sloping arises out of the design or the construction?
I would rely on paragraphs 5, 6, 7, and 8.
Which language?
It would be that in paragraph 5 that it was installed since in 1992.
How does that get us there? That's just a fact that that's when it was installed.
And I'm putting these together and reading them together to analyze the complaint. And if you have it that it was installed in 1992, it is designed as a dry system such that water should not remain in the lines.
Okay.
Then if you have water in the lines, then we have a design defect, or we have...
Is that your surmise? I don't hear that in the language of the complaint, which you have gone back to over and over again. I would like for you to pinpoint, rather than kind of arm-waving at several paragraphs, I want you to point me to particular language that meets the burden that you have.
I think the only thing that I can point you to, Justice Kirby, is those paragraphs in the complaint.
So just the fact that there was sloping and the fact that it was installed.
the complaint specifically says improper sloping. And so when you take
Right. How do we know that that is arising out of the design or construction? That's my question.
I think the answer to that question is that in paragraph 5, it was installed in 1992, and that sloping was improper from 1992.
Wait, does it say from 1992? Where does it say that?
It does not say that.
Okay.
It does not say that.
Okay.
But
So you're making an inference.
a reasonable inference, I would assert.
Well,
given-
is it an unreasonable inference that it may have occurred later? That it occurred unrelated to the design or the construction? Because we are at a motion to dismiss posture, and that requires us to draw reasonable inferences in favor of the plaintiff.
I think.
And it may be that it's maybe there are multiple reasonable inferences here, but it would have to be an unreasonable inference that it occurred later for us to draw the inference you're asking us to draw.
I think, in review of the complaint, that is the only reasonable inference that can be drawn, is that from installation, where this system was designed to be a dry system, the fact that the plaintiff specifically used the term improper sloping, that indicates that the design was improper or the construction was improper. And I think when you have that, I think that's where we get that is the only reasonable inference, is that this was a construction defect or a design defect that arose from 1992, or that was in place as of 1992. There was a later water line burst well after the repose statute ran. Because East Tennessee Sprinkler was the installer of that, East Tennessee Sprinkler is entitled to rely on the repose statute. That would be the argument that I would make in response to that.
Do you think, so here's what we said in Red Wing, that when the allegations in the complaint on their face establish, so in Red Wing was a statute of limitations, not a statute of repose, but when the allegations of the complaint are sufficient to establish a statute of limitations defense, the burden then shifts to the plaintiff to demonstrate that the allegations are sufficient to articulate at least a colorable basis for concluding that the statute of limitations has not run. In your view, does that kind of burden shifting framework that we set out in Red Wing, does that sort of change the way we view the allegations of the complaint? Does that impose some sort of heightened pleading obligation on the plaintiff in this context? In other words, do we have to look for actual allegations in the complaint that, provide a basis for concluding that the statute of limitations or statute of repose doesn't exist or doesn't apply? Or can we draw inferences from the complaint to reach that conclusion?
I think the answer to that is that there has to be factual allegations in the complaint sufficient to show that the repose statute does not apply. That would be my answer to that. And I think that
So how is that reasonable? The statute of repose is an affirmative defense, just like the statute of limitations. You have the burden of showing that you are entitled to that defense. Don't you have to point to language on the face of the complaint that demonstrates that you are entitled to rely on that defense?
I think we have to. I think we have. And I think when we look at the factual allegations in the complaint, and candidly, those paragraphs that we've referred to repeatedly, 5, 6, 7, 8, those are really the sole factual allegations in the complaint. And we saw in the plaintiff's brief there was an attempt to add to the record and to supplement.
The plaintiff is not the only one adding to the complaint. What I hear is you adding to the complaint also, saying that the improper sloping occurred in 1992, when the face of the complaint does not say that.
With respect, I would assert that given the installation, the fact that it was supposed to be a dry system and there's an allegation of improper sloping, I think we are relying on the actual allegations in the complaint to make our position. My time has.
I see your time's up. I still want to ask you one more question. Now, getting back to Justice Campbell's question about Red Wing, I didn't hear an answer to her question about, do you think that that framework, as we set forth in Red Wing, should apply in a statute of repose case like it does in a statute of limitation case?
I would submit yes. The last thing I would add, given that my time has expired, is just wanted to confirm the relief that we request, which is that the court overturn the Court of Appeals decision and affirm the award by the trial court of the attorney's fees that were awarded under Section 20-12-119. Thank you all very much.
May it please the court, Jonathan Masters on behalf of Tri-State. This is a Rule 12 case, as this bench is already well noted. The only question here is whether the complaint, read liberally, states a claim against East Tennessee. The Court of Appeals got it right, finding that the heart of the claims and allegations alleged in the complaint are about East Tennessee's ongoing failures to properly inspect, test, maintain, and repair the system during its annual inspections, all of which occurred after the initial installation. The statute of repose does not apply here, and likewise, the award of any fees below should fall as well.
Mr. Masters, if I could direct you actually to the language of the statute of repose. It appears to bar all claims arising, all claims, all means all, arising out of any deficiency in the construction of an improvement to real property. How is it that we should interpret the phrase all claims arising out of?
I don't think we need to do any particular fancy dance in this situation, Your Honor. If this case and if the facts allege that in fact the initial design and construction was faulty, then yes, I think the statute of repose would apply. And that is all claims relating to, arising out of. This case is different and does not allege that. In fact, paragraph 5 of the complaint says, since 1992, they have come, East Tennessee has come back and performed these inspections. I don't believe just because East Tennessee happened to do the installation and then also took on separate obligations year after year after year after year to inspect, that it gets blanket immunity for 30 years worth of inspections following that. The confusion, I suppose, in this case is it just happens to be the same company. But the same company accepted and did different work under different standards. The duty arose each time East Tennessee appeared and came and undertook those responsibilities. The same as in your hypothetical with Joe that you raised earlier, Your Honor. If Joe comes back, each time he undertakes that responsibility to perform professional service, he has certain duties that Joe must maintain and are obligated to follow at each time.
So your position, as I understand it, and don't let me put words in your mouth,
Sure.
but it must be that any claim for improper work in 1992 and the deficiency in the design in 1992 is barred by the statute of repose.
I think that's correct. I think that's absolutely correct. But again, that's not what our complaint alleges in this case. Your
But your complaint alleges there was improper sloping, correct?
Absolutely.
But it does not allege that that improper sloping occurred after the installation, does it?
It does not allege that, but regardless of when the improper sloping would have arisen, it should have been noted in those subsequent additional inspections. Again, the complaint cites to the national standards of what those inspections are to entail. And if the inspection was part of that original or somehow developed as a result of settling or something else, those are factual disputes. And of course, we're here on Rule 12, but nevertheless, those subsequent obligations, those subsequent duties, were those annual inspections year after year after year.
Is it really a factual dispute? Because you do not allege in your complaint that the sloping took place after the installation, do you?
I do not. It's not specific.
So then how is there a factual dispute as to that? Wouldn't again, the only reasonable inference be that the sloping, the improper sloping occurred because of a design or a construction defect?
I don't think that's correct at all. We don't know when the improper sloping occurred. We don't know how the improper sloping occurred. What we do know is that East Tennessee came year after year after year, never noted it, never recommended it, never said what happened, and as a result, water was allowed to rest in the dry system and then rust and then ultimately cause the significant damage that we're dealing with here in this case.
But under the statute of repose, though, let's look at the language of the statute of repose. It provides that, so it applies to actions, arbitrations, or other binding dispute resolution proceedings to recover damages for any deficiency in the design, planning, supervision, et cetera. So the focus is on the damages for the deficiency in one of those things, right? And if the improper sloping existed, it was part of the construction of this system. So it existed from the very beginning. It was either, I mean, I assume based on the allegations in your complaint, it wasn't part of the design because the design was not to have water collect. But if the construction was improper and didn't follow the design such that that's the cause of the damage, then why does it matter whether there was any sort of ongoing duty to supervise?
Because those are separate agreements. Again, back to Justice Tarwater's example. If we had a subsequent, another Joe had come in and done this, Joe would be responsible for the proper inspection, maintenance recommendations, and so forth. The fact that it just so happens to be the same company that installed should not matter. In our view, it's of no import. They accepted these separate responsibilities. They accepted to inspect, repair, make recommendations, regardless of what had occurred before in the install. And they should be held and obligated to abide by those duties and should not be granted blanket immunity for the end of time each time they come out there every year simply because of the condition they also happen to have made the installation. I don't believe
But the negligent inspection isn't really the cause of the damages. I mean, that if you trace back, what actually caused the damages, it's the improper sloping.
Well,
I mean, that's really what your complaint alleges. And that seems to fall squarely within the statute of repose, regardless of whether there was any sort of ongoing duty to supervise.
Respectfully, I disagree.
Or to inspect, rather.
Had the inspections, repairs, recommendations, as required by the national standards, been applied and been undertaken, at the very least they would have noted and recommended that the system was holding water. At the very least they would have noted and recommended that repairs were necessary. At any of that period of time, once the water started pooling. Eventually we'll get to this. We have experts who have reviewed this system and all, but again, we get outside the arena of Rule 12. I believe the allegations are clear. Again, paragraph 5 talks about since 1992. Paragraph 7, 8, 9, 10, 11, and 12 all talk about the maintenance, repairs, and the continuing efforts that and the return of each of these. And then, of course, paragraphs 21 and 24 likewise specifically discuss in a realm of a breach of contract claim regarding to all those. Your Honor, I think it would make a difference. I think it very well would have made a difference, and I think there are individual duties each time East Tennessee came back. And I don't believe we should get overly hung up with the fact that East Tennessee also happened to do the do the install, when in fact they had separate duties, separate responsibilities at each of the return that they made when they came to inspect the system year after year.
Mr. Masters, I'm sorry, Justice Campbell. We like to ask questions up here, okay?
Thank you. Makes my job easier, I think.
And sometimes you have to be pretty quick, you know, to get one in. And no, I'd like to ask you just maybe a more simple question, not a fancy dancy question, but how is it that your claim does not arise out of the original construction defect of improper sloping?
I think it's really a lot what I was just answering to Judge Campbell, I believe. Regardless of what the sloping may or may not have been at the install, first of all, the allegations, there's nothing in the complaint that specifically alleges when the sloping occurred. We'll get to that, and we have experts that will
It's your complaint.
to that. And I'm sorry?
I just said it's your complaint, right?
It is
you,
my
you
complaint.
chose not to amend it.
It is my complaint, and without question. And Your Honor, but I do believe that the crux and the heart of these allegations all go to the ongoing maintenance the maintenance inspection that occurred year after year after year after year, regardless of what may or may not have been there. I don't believe this court should enter a rule that the statute of limitations would provide a lifetime shield under this sort of, I guess, maybe unique set of circumstances where the same entity who installed also came back and did all these inspections. Again, if Joe had come out there, Joe may very well have said, hey, your sloping is incorrect, it's holding water. If you don't do something about this campus chalet, you're going to have a big problem. That never occurred, and that's the crux of the case.
But part of what we're dealing with here, is it not, Mr. Masters, is the fact that the legislature has made a policy determination that there should be a bar in many instances. So it's not as simple as saying that, okay, well, they were over here inspecting and doing that. We have to parse out a very strong public policy component that the legislature has put forward with regard to the statute of repose. Do we not?
Well, I agree, but I don't believe the legislature intended for some sort of blanket immunity when this company continues to come back, continues to do these separate new actions. If the court's looking for a bright line under a Rule 12 analysis, it could be this. 28-3202 bars claims seeking damages because the improvements were deficient when substantially complete. It does not bar later independent duties arising from later service, maintenance contracts, and later professional negligence in performing those services. And that's what we have here. I think that is a rule that this court could bite on, create some sort of guidance in the future for folks. But I believe our complaint under the Rule 12 analysis clearly identifies and states the ongoing failures year after year after year. And I believe the Court of Appeals got it right and properly looked at the heart of the claims and the heart of what is alleged, giving the liberal view and the benefit of the doubt to the plaintiffs in this case, and overturned the lower courts. And I believe this court should affirm the Court of Appeals and return this case to the lower court.
Mr. Masters, before you wrap up, I do have another question.
I welcome any questions. Thank you, Judge.
So going back to the Red Wing framework that we talked about with your friend on the other side, is there any reason why that framework should not extend to the statute of repose context? Red Wing was statute of limitations.
I don't see any reason why it wouldn't. I think the context at the end of the day is essentially the same. And I think in a Rule 12 context, when you're reviewing that and looking at the complaint, I believe it makes sense that would apply.
And what allegations in your complaint provide a colorable basis for concluding that the statute of repose does not apply here?
Well, specifically, Your Honor, we could first go to paragraph 5 of the complaint, where East Tennessee Sprinkler inspected, repaired, and maintained the system at Campus Chalet since 1982. Paragraph 8, which was already brought up, I believe, by Justice Kirby, there was a lot of discussion about the first sentence, but the second sentence was not discussed, and in that sentence it says, the improper sloping could and should have been identified, detected during East Tennessee Services inspections, maintenance, and repairs to the Campus Chalet. Paragraph 9, the second phrase, that East Tennessee didn't advise of the need to repair of the sloping of the water pooling. Paragraph 11, again, talks about the improper maintenance testing and repairs were not performed by East Tennessee in a proper manner. Paragraph 21 and 24 also repeat the failure of the inspections and the maintenance.
So you're really relying on, your theory that this was a separate duty, this was a kind of separate cause of the damages, not on, are you asking us to, I guess, draw a reasonable inference from the allegations that the improper sloping began post-construction?
I believe that's certainly reasonable as it's pled at this point, but I don't think it's completely dispositive as to whether or not the motion.
So you don't think we need to do that for you to win?
I do not, Your Honor.
But if we think you do need to do that to win, you would.
Well,
your
I guess
position is that is a permissible inference from your complaint.
Well, I guess that is correct, Your Honor. It is. I don't believe, however, that I think the complaint is clear on what is being alleged here, and it's repeated over and over throughout. And I believe the Court of Appeals followed that, found that, and I believe got it right. And again, I would ask this court to affirm the Court of Appeals, send us back to Washington County so we can continue with discovery and get to some of these details that have been raised in this matter. Are there any other questions? Otherwise, that is.
So even if the crux of your complaint is failure to inspect and advise of the issues related to the sloping, how does that still not arise out of the defect if in fact the sloping, let's just assume for purposes of argument that your opposing counsel is correct that the only reasonable inference is that the sloping occurred in 1992. Does that sink your boat?
No. First of all, I'm not 100% sure that
Because even if your allegations are failure to inspect and advise, the ultimate injury, which is what the statute of repose is based on, arises out of the sloping, right?
Well, first of all, we don't know, and there's no allegations, and I think I've said of when the sloping occurred. I believe, again, that is a factual issue that must be determined by our experts in discovery.
I understand that.
If and ever we get there. But at the same time, I don't think it floats the boats because I think sinks my boat. I think it floats my boat because there were separate and individual duties each time they came out and did those inspections. And at any one of those, regardless of when the sloping occurred, they had a duty at that time.
I understand that, but the arising out of language is quite broad. How does that not catch you?
I think it intervenes and cuts off. And again, we get back to certainly the legislature did not intend to be a blanket immunity to go on forever for negligent actions.
We do occasionally have statutes that are written in a way that don't necessarily reflect what the legislature probably intended. So what I'm asking is that if that's what we got here.
I think that's well, let me be careful how I say that. I think that's certainly what East Tennessee is trying to adopt and to tag on here. I believe it is ultimately a bad conclusion that we do that. We should not have these types of actions going on. Joe would not be entitled to that type of protection under Judge Tarwater's. He would be here. We would probably never been here in this posture. We would have continued on. And I think that's reasonable. So why should Joe be subject to that? And in here, they shouldn't, when effectively East Tennessee was doing the exact same thing that Joe was doing year after year after year, and in a negligent manner. I don't think the statute should be read that way. I guess I can't say for sure what the legislature intended, but it certainly would lead to, in my view, a preposterous result of shielding inspection companies on something that's critically and vitally important. There's sprinkler systems probably in this building, Your Honors.
Thank you.
All right. Any other questions? I have nothing further than thank you, Your Honors. I appreciate
Thank you,
your
Counsel.
time.
Mr. Howell?
Yes, Justice Bivens. I would say in rebuttal that this idea that there is not the quote has been used, a blanket immunity, there was a specific intent by the legislature to provide immunity, and this court has recognized that in Crisman. And the quote from the Crisman case, page 540, in enacting the statute, the General Assembly intended to insulate contractors, architects, engineers, and others from liability for defective construction or design of improvements to realty where the injury happens more than 4 years after substantial completion of the improvement. And so with regard to those issues, there has been a public policy decision by the legislature and as interpreted by this court that persons such as East Tennessee Sprinkler who are alleged to have liability for defective design or construction, they are entitled to that protection once 4 years has passed from substantial completion. So I would address that. One of the other points that I wanted to address with regard to the complaint, and we're talking about the issue of this improper sloping and potentially when it arose. In looking at the complaint, the only date that is provided is from 1992. There is not an alternative date of injury provided in the complaint in looking at the factual allegations of the complaint, of which the plaintiff was the master of their complaint.
So does your success pivot on who has the burden in the context of your motion to dismiss? Do you, as the party who is asserting the protection of the statute of repose, have the burden of showing, based on the language in the complaint, that you are entitled to that defense? Or does the plaintiff have the burden of proving a negative, showing a negative, that the language of the complaint is such that it excludes application of the statute of repose? And I'm puzzled because there could certainly be a mixed situation where the injury ultimately occurs is partially related to something related to the design and partially related to the fact that the building settled and that exacerbated whatever the design. I mean, we could have a lot of different nuances here. So does your success pivot on who has that burden in the context of a motion to dismiss?
I would respond to that by saying no, in the sense that this complaint is barred by the statute of repose given the way it was drafted. Plaintiff was the master of it. The only reasonable inference is that this is arising out of the alleged deficiency in the design or construction. And so it is facially apparent from this complaint that it is barred by the statute of repose.
So for us to rule in your favor, we would have to agree with you that that is the sole reasonable inference from the language of the complaint. Is that correct?
I would say yes, because I think it is the only reasonable inference that can be drawn given the facts of the case, or the facts of the complaint. And we are bound and this court is bound by what's in the record, and it's these facts, and that's what we have based our argument on. And so that's how I would respond to that.
Mr. Howell, let me ask you, did you file an answer in this case, or did you just file a motion to dismiss?
We just filed a motion to dismiss.
Okay. So this allegation of improper sloping, that's the allegation, but there's nothing in this record that actually admits that the sloping was improper, is there?
There would be well,
Other than the fact that the sprinkler system busted up and squirted water all over the place, right?
My response to that would be, did we file an answer and admit that yes or no, or deny that yes or no? No, we did not. We filed a motion to dismiss. But under this court's decision in Webb, if we have these allegations that must be accepted as true, then we have a factual allegation of improper sloping of the sprinkler system, which dates back to installation to 1992.
So we take that as true?
We take that as true. Or this court would take that as true.
Yeah, but that was we.
Understood. It's
Us,
not
we.
me. It's not me. The last, as my time draws to a close, there was repeated reference to these continuing allegations of inspections and duties assumed under contract. None of that's pled. There are no factual support for that. And as the trial court made this point, that's under Rule 1003, Tennessee Rules of Civil Procedure. If there are such of those documents that are to have a bearing or to relate to the claim that's being made by plaintiff, they are to be attached. Or one of the exceptions to 1003 is supposed to be alleged, and it's not. And so we don't have any of that. That's not in the record. And the last point, unless there are further questions, I think the question and the analysis about the breadth of the language from the repose statute of, as I flip over to it, arising out of any such deficiency, that language is very broad. We cited a case from the insurance context in our brief. The language that has been used before, originating from, growing out of, flowing from, that language is very broad. And I think, as some of the questions were asked, it is clear from this complaint that the cause of action that was actually pled is something that arises out of a deficiency in the design or construction, and therefore the statute of repose would apply, and East Tennessee Sprinkler is a person who is entitled to the benefit, the protection of that statute as intended by the legislature, as acknowledged by this court in Chrisman. And if there are no other questions, I'll conclude my argument. And again, we ask that the Court of Appeals decision be reversed and that the award of attorney's fees be from the trial court be affirmed. Thank you all very much.
Thank you, counsel. We appreciate that. All right, court will take a brief recess and be back for our second case.
All rise.